So thank you very much for the invitation to address the Joint Committee. My name is David Alberts-Jones, and I'm Director of the Anscombe Bioethics Centre in Oxford and Professor of Bioethics at St Mary's University in Twickenham. The first thing I would like to flag up is the importance in this context of unambiguous terminology, or at least terminology which is as clear as we can get it. From this point of view, the phrase assisted dying, though it's been used by this committee, is problematic, is challenging, because it's used by different people to mean different things. And you can see that internationally. If this phrase is going to be used, I think that we need to agree what its meaning when we used, what it's used for, and I would suggest that the most helpful, the least problematic meaning is as an umbrella term for different forms of euthanasia or physician-assisted suicide which exist in different jurisdictions. So use it as an umbrella term. The topic for today, or at least the topic I was given, is developing a legal framework for assisted dying. But of course, there is a legal framework for assisted dying in Ireland. The framework is that euthanasia is illegal under common law and under the Criminal Justice Act of 1964, and assisted suicide is illegal under the Criminal Law Suicide Act of 1993, as upheld by Fleming versus Ireland in 2013. Which puts Ireland among the 180 or so countries in the world where euthanasia or assisted suicide are prohibited or are not practiced, rather than among the dozen or so where they are available. There are differences between different legal frameworks which provide either euthanasia and or assisted suicide. And we can talk about these different frameworks. But in my view, what they have in common is more significant than how they differ. So those countries, those dozen or so countries which have introduced some form of assisted dying, have all abandoned a principle of healthcare ethics which is as old as Hippocrates, and a principle of a legal principle which is in most countries of the world, prohibiting the intentional taking of life. This is a radical change, I think. And because it's a radical change, this has practical implications. If you cross the Rubicon, as it were, it's very difficult then to have lesser barriers which will be as effective. If we've abandoned this very well established, historically, very deeply rooted rule against euthanasia and assisted suicide, for how long could we maintain a much more arbitrary rule, such as that it should be available for people with 6 months to live, but not for people with 7 months to live? That's obviously not as fundamental a principle. Or it should be permitted for this diagnosis, but not for that diagnosis. If we look at what happens in these different jurisdictions, and this is something common to the different jurisdictions, is that numbers go up in every jurisdiction, categories tend to expand, and restrictions tend to drop away. Nor is it only the extension of the law, the future extension of the law, which should concern us, and therefore you might say restrictions or requirements within the law. It's also the impact of the law outside, the impact of the law on wider society. We need to consider, how does this legal change affect the perception, both the self-perception and the perception by others, that someone might feel a burden to society? How does it impact the way that other medical decisions are made? How does it impact the cultural acceptability of suicide, I mean unassisted suicide, for people who have severe physical or mental disabilities? We know that unassisted suicide rates have increased significantly in the United States, in those states which have legalized assisted dying, in comparison to those that have not. The legal framework now in place in Ireland and in the United Kingdom, and in this area of law they're very similar, which prohibits euthanasia and assisted suicide, but allows other end-of-life decisions, such as withdrawal of treatment and the giving of treatment which has risks or side effects, offers a clear, bright line, I would suggest, which is much more robust, much more protective than any collection of ad hoc requirements after you take this bright line away. Once the dam has been breached, I think it is naive to think that a series of makeshift barriers will have the same protective effect. And that's what we're talking about. Thank you very much.